Welcome back to Good Law, Bad Law. My guest on this episode is Professor Joyce Malcolm. She is the Patrick Henry Professor of Constitutional Law at the newly renamed Antonin Scalia Law School at George Mason University. And we are talking about the legacy of Justice Anthony Kennedy, his retirement from the Supreme Court after 30 years, some of the leading decisions in the area of gay and lesbian rights, the area of abortion rights. What is his legacy and where is the Supreme Court going now with his retirement, a pending nomination of Brett Kavanaugh to replace him? What does this signal in terms of how not only the makeup of the Supreme Court, but the direction of the Supreme Court may be changing? An important conversation with a very experienced and fascinating constitutional law historian. I hope you'll enjoy this episode. My guest today on Good Law, Bad Law is Professor Joyce Malcolm. First of all, thank you very much for being on the program, Professor Malcolm.
Oh, thank you very much for inviting me.
I want to talk about the legacy of Justice Anthony Kennedy. This is a justice who served on the Supreme Court for 30 years, and his seat is being talked about, worried over, hand-wringing, excitement. I mean, all across the spectrum as people anticipate confirmation hearings for Brett Kavanaugh, for Judge Kavanaugh. But I want to start and give some background on you, Professor Malcolm. I know you are the Patrick Henry Professor of Constitutional Law at George Mason University School of Law, now the Antonin Scalia Law School.
Yeah, I'm glad you added that. My dean will be grateful.
When did the name change? I'm sure that was sometime shortly
over
after
a year
you passed.
ago.
Uh-huh.
Yes, it was, and we got a big grant, an anonymous grant that included a lot of money for student scholarships, but also asked that we change the name of the law school. I think everyone was quite pleased to do that because, however you agree or disagree with Scalia's opinions, he really was one of the greatest jurists, of the last century, and had a big impact on the way that the court sees the law. At the renaming ceremony, Justice Kagan gave the talk about Scalia, and she pointed out that all of them now see their role and the interpretation of law differently than they had before because of him. Wow. So it was quite a great testimonial.
That is an incredible legacy. And he had some words about his fellow Justice Kennedy that we'll get to in a couple of minutes. But give us some background on yourself, Professor Malcolm, because I know you've had a fascinating career yourself and actually had an important influence on one of Justice Scalia's most important decisions while he was on the court, the Heller case. So give us a little bit of background on yourself, please.
Well, actually, I am a historian. I'm not a lawyer, although I teach at a law school, but I've written on legal and constitutional history. And my book, To Keep and Bear Arms, The Origins of an Anglo-American Right, was cited by the majority in the Heller case, and that's the case that confirmed that the Second Amendment was an individual right and overturned Washington, D.C.'s ban on the possession of handguns by its residents. So that was a really landmark case, and I feel quite honored to have had work that I had done, been of use to the courts. But I have written I've written further on the right to be armed and also compared the American right to the British right, the way that it used to be when we were a colony and were concerned about our rights as Englishmen, and what has now happened in the UK, and as the right has been more and more diminished. So I'm interested in that. I've written on colonial America, and I have a new book just published on a biography of Benedict Arnold called The Tragedy of Benedict Arnold. So I've sort of followed my interest in lots of directions.
Wow. Okay, great. And the Benedict Arnold book is published. Who's the publisher, and is that available now?
Pegasus. Yes, it is. Pegasus Press can be purchased at Amazon, and as they say, wherever books are sold.
Which is basically Amazon.
Amazon seems to be the place most books are sold these days.
Exactly. And I know you've also taught at Princeton and Boston University, Northeastern, and at Cambridge prior to getting your position at George Mason. So to teach constitutional law at a law school, and the Scalia Law School, we now call it, you're teaching impressionable lawyers, would-be lawyers, about the history and development of law, really at the level of the Supreme Court. So you have, I know, paid close attention to the evolution of important issues that have come before the court. And to do that, you also have to pay very close attention to individual justices on the Supreme Court. I imagine that's true, right?
Yes, it is. It's interesting because our court, I teach one course on comparative constitutional law, and it seems to be only in America that the members of our Supreme Court are really like rock stars. Everyone knows their names. Mm-hmm. Whenever they go anywhere, their talks are very well attended. I mean, they're really known for their opinions and personalities in a particular way. They're extremely important in our system, probably far more than the Supreme Court was ever meant to be, actually.
Well, and because we have lifetime appointment to our federal courts, including the Supreme Court, there's also this, I think this great mystery. We know the process is the president nominates and the Senate has to, through its advice and consent responsibilities, has to confirm. But once that individual is on the court, and only much more importantly on the Supreme Court, anything can happen. And sometimes anything does happen, and there's been some famous examples of that. And I wonder, as you look back, Anthony Kennedy was nominated in 1987, and it came on the heels of some very controversial confirmation battles. Importantly, the battle over Judge Robert Bork, who failed to be confirmed. And then Kennedy sailed through his confirmation. I actually was a writer in Washington and covered Justice Kennedy's nomination. Yeah, this was before law school, and I was writing for a weekly newspaper then called Legal Times, and I actually remember going out to California and after he was nominated and researching his background out there, his political connections, lobbying connections, and importantly, his relationship to then Governor Ronald Reagan. So Reagan becomes president, and Kennedy is nominated. And after the controversies over Bork, Kennedy sails through the Senate on a 97-0 vote, ultimately confirming. But then he's got a tenure on the court of 30 years and a very interesting and varied role on the court during those 3 decades. So if you were to be asked, as I'm now going to ask you, to really do something that I know is really oversimplifying, but to kind of sum up that legacy, and then we'll get into some of the specific issues he's confronted. How would you characterize his role over these 30 years?
I should just say, in the context you were talking about his confirmation, mm-hmm. that debate over Bork's confirmation was really the beginning of these highly contentious and partisan debates over Supreme Court nominations, and they've gone on that way since. I mean, Kennedy was lucky he came when he did.
Yes,
but
right.
That legacy has not been very happy one for us. But Kennedy doesn't seem or hasn't seemed to have any particular ideology, except that I think he had a kind of expansive view of the importance of the Supreme Court, in its decisions, rather than the fact that the court maybe should have a more modest role. So over those 30 years, he has been the writer of opinions that pleased, conservatives, and the writers of other opinions that pleased progressives. And after Sandra Day O'Connor left the court in 2006, Kennedy became a sort of official swing vote. And basically, so many really important decisions were 5-4 decisions in which he cast the deciding vote. In the Heller case, this Second Amendment case, he voted with the majority that there was clear evidence that the Second Amendment was an individual right. But within the opinion, the Scalia who wrote it has one paragraph in which he said that, of course, the fact that it's an individual right and guns that are in common use, people have a right to have for legal purposes. There's this section about how, of course, this doesn't negate bans on guns in sensitive places and keeping them out of the hands of felons, etc. And that particular paragraph has been attributed to the desire to have Kennedy sign that opinion. Now, I don't know for certain, but it sounds like the sort of thing he might have wanted to do. And, immediately there was this sort of guessing that he was the one that they were wooing by putting that in. So his views have really been extremely important in swaying things. And, for better or for worse, it's difficult to know and which way he would go on a case. And I don't think that's a good thing. Not that people should be, knee-jerk conservatives or liberals, but he didn't necessarily seem to focus strictly on what the Constitution says and the impact of it. I don't know whether you want now to get into particular opinions.
Well, I want to stay on this idea of a swing vote because it's I think perhaps one of the things that people worry about, and it depends where you're coming from and what your issues are. And we're going to talk about some of those specific issues. But if you're, for instance, very concerned about the future of Roe v. Wade or the future of some of the gay and lesbian rights opinions that Justice Kennedy was involved in, or First Amendment issues that his vote was very key on. And that over a lot of years now, we've had a closely divided court ideologically, as much as you can say justices are ideological. And he has, as you pointed out, sometimes pleasing one side and sometimes pleasing the other side by his fifth vote in a 5-4 vote. That are we perhaps at the end of an era of there being a justice who holds that swing vote mantle as much as Justice Kennedy has held it over these last many years? I mean,
it's very hard to know. Yeah, it's hard to know because, as you mentioned before, since the justices are there for life, once appointed, they seem to evolve. So a lot of justices who were appointed because they held conservative views end up in, more moderate or liberal. For some reason, it doesn't seem to go the other way. But you really cannot tell. And as I say, before he was a swing vote, it was Sandra Day O'Connor, who was also a conservative appointment and was the sort of swing voter. So I have a feeling that even after Kavanaugh is put on the court, which I assume he will be, that there may be some other judge there who is going to take on that role, maybe Roberts. You really don't know because they are free agents. I mean, what they ought to be looking at is the law and the Constitution and not setting policy for the country, because that really is what the Democratic branches are supposed to do. But I suspect that there will be somebody else on that court who may go one way or the other. And I don't feel comfortable with the idea that one judge makes important decisions for a country of over 300 million people.
Right.
So in that sense, do we really want someone who's going to be the decisive vote on these very close cases?
Well,
I think it's.
That's really what I was
Go
wondering.
ahead.
I mean, it seems to me kind of unfair, really, to the other 8 justices to refer to Justice Kennedy as the swing vote or the swing justice. Justice Kagan, who you mentioned earlier, as speaking at Justice Scalia's at the naming of your law school for the late Justice Scalia, she described she was speaking about Justice Kennedy as having been referred to as the swing vote, and she says, "I think the description fails to capture the essence of what makes Justice Kennedy such an important figure: his independence, his integrity, his unique and evolving vision. Far from swinging between positions defined by others, Justice Kennedy has consistently charted his own course." And that's a very nice thing to say about Justice Kennedy. But when I heard that, I thought, well, gee, are these other 8 justices really just the liberal justices on one hand and the 4 conservative justices on the other? I mean, you look at the decisions over the course of a Supreme Court term or several terms, and that isn't how it works.
It shouldn't be how it works, really. And I think that part of the problem, as I see it, is that the judges have taken a much more central role in the setting of policy, the social policies and having the deciding vote, as it were, on the major issues facing our country. And one of the things that struck me thinking about this was in the Obergefell same-sex marriage case. In his dissent, Justice Roberts said, "Who do we think we are? We're 9 appointed justices." And I think that's it. Who are they? I mean, should one judge make those decisions for everyone? Isn't it better that the court have a somewhat more modest sense of its own role, so that that the democratic branches of the country, make the decisions that reflect what the legislatures and the law ought to be, and the judge's role really is to enforce it or check on its constitutionality. But it's uncomfortable. Yeah.
Yeah. Well, that's why I've always thought it has to be a very lonely job sometimes, because I mean, we have 1 president, we have 535 members of Congress, and we have 9 members of the Supreme Court. It's an elite group at any one moment. But I think that's the tension, isn't it? And they have to be servants to the Constitution. Otherwise, we might still have segregated schools, or we might have bans at the state level on interracial marriage, and a whole host of other important issues that the Supreme Court, those 9 men and now women, say, well, no. This is what the Constitution requires, and we're servants to the Constitution. So that part is the way it is supposed to work, isn't it? So
that part is. It's just that the idea of sort of, I don't want to sound too contentious about this, but sort of finding new rights, or sort of having an open-ended idea of what would be good policy is a problem. And I remember, I've done a lot of work on the founding era, and and Justice Blackstone from England was talked about the difference between law and equity, and which our courts combined. And he said that in equity, the opinion is in the breast of every judge, and you never know what that judge is going to want to do. So too much equity is not a good thing. The law can be harsh, but equity leaves you without being sure which way you're going. And I think that there's this tendency to want to sort of correct something or or preempt. And in the Obergefell decision, the dissenters felt that the states were handling this in a democratic way, and that the Supreme Court kind of came in and put its foot on it and said, this is the way it ought to be, and everybody needs to go along, whereas if they had left it, presumably it might have come to that same result. So I think a lot of it is the role that the Supreme Court has taken for itself, and now has, sort of the final say. As I tell my students, of when we can be born and when we die and everything in between. They're sort of leaping over the structure, the federalist structure and the legislative structure sometimes, and kind of assuming that everything is a constitutional issue they need to weigh in on.
Well,
although I should say, to be fair, they don't take many cases. So there are many cases I wish they would have taken.
Yeah. I mean, that is an important point. But when we look back at this justice's career, and you've mentioned the same-sex marriage case from 2015, the Obergefell case, a couple of times, and so let's dive in there, because probably from everything I've read and seen in the area of gay and lesbian rights, this has to be seen as one of his most visible and even the way he's written those opinions, the language, probably a justice prone to lofty language, but especially so in these cases, the very sweeping and almost poetic language on dignity and liberty when it comes to some of these key decisions that he's really been identified with. The Obergefell case 2015, but there were others before that. The Lawrence versus Texas case, for instance, that overruled the Bowers decision by the Supreme Court that allowed states to outlaw sodomy, which was basically, the way we understand it today, was criminalizing homosexual sex. So Kennedy was, really cutting his teeth in terms of his language in that case, leading up to the same-sex marriage case. So how do you, as a constitutional scholar, how do you assess, those cases and the relative importance of those cases?
Well, they obviously are extraordinarily important, very basic kind of social issues. But I think they go also to the Federalist issue of what belongs to the states, what area the states have, what role they have, and what role the central government and the Constitution, federal Constitution, have. And he's sort of arguing that when you get to these issues of privacy and personal dignity, that all of that should be decided at the federal level. So that, in a sense, kind of enlarges the Supreme Court's decisions on this. He also wrote Planned Parenthood versus Casey, which is the present rule on that led on from Roe v. Wade, and changed basically kind of gutted the standard that Roe v. Wade had of a trimester for abortion, to change it to an undue burden standard, which has in 1992. So they kept the right, but completely changed the way that they were going to reconfigure it, and caused a whole lot of confusion in the sense that virtually all kinds of regulations of any sort on abortion can be interpreted or challenged as an undue burden. I mean, I think he had a very clear sense of what he felt was a key individual right and personal right. but there was all this uncertainty as to whether that was for the Supreme Court to decide, whether that was for one judge to decide, based on his own kind of gut sense of what was a deep personal right, rather than sort of looking at, well, what does the Constitution say? What do our statutes say? And where does the Supreme Court actually need to weigh in?
Well, it's what you're
I think
saying
his
now.
decisions have been. Yeah.
No, go ahead. I'm sorry. Please.
I'm not saying that his ultimate decisions were wrong. It just is, you never knew what they were going to be. I think that's the part. I don't like the idea that someone is, rigidly on the left or on the right, but he didn't seem to have the kind of a clear-cut legal approach that you could sort of know for certain how he was going to come out.
Well, there's a couple of things that I'm thinking about as I'm listening to you that I want to follow up on. One is that just on that last point, one of the things I was reading, getting as prepared as I can be said to be right now, because we're covering a lot of issues, and I'm doing my best to keep up. But one of the things that I noted that he talked about during his confirmation. So this is going now back to early 1988, and may also be something we can refer back to in a little bit when we get to talking about Judge Kavanaugh and his upcoming confirmation, because I think in the days since the defeat of Robert Bork for the Supreme Court and everything that happened then, as you mentioned, the way judges and justices get confirmed has changed a lot, and maybe less is said than once upon a time. But one of the things that Justice Kennedy did note when he was asked about Roe versus Wade and some of the other important privacy decisions by the Supreme Court, including the Griswold case, which was about an individual's right to or at least a married couple's right to contraception. And he talked about there being a zone of liberty within which the government can't intrude within that zone of liberty. And that being so central to the notion of liberty under our Constitution. And so is that something that can perhaps define in some way Justice Kennedy's approach to at least these social issues that we've talked about so far, whether it's same-sex marriage, decriminalizing homosexuality, abortion, to say there is this zone that within which there is this individual right. That's not to say that the government, state or federal, has to back off completely. There are some ways that we may look at the reasonableness of a government regulation, but we do have to respect the dignity and liberty that exists within some zone of personal privacy, of personal liberty.
I think that's perfectly true. And he obviously felt very strongly about that, as his opinions, emphasize. It's just that when someone is sort of labeled swing vote, it's hard to know how they're seeing that. I mean, there obviously are all kinds of rights that are not in the Bill of Rights, and in fact, in Britain, they didn't like to have a definitive Bill of Rights. It didn't, because they felt that if whatever you left out, would be forever left out. And our founders didn't agree with that, but they put in the 9th and 10th Amendment to try to cover anything that might have been left out. So I can understand that, and I'm I know he felt very strongly and weighed all these things in carefully. It's just, and perhaps that it's because the Supreme Court has taken such a very large role in all of our lives and in these big decisions, that the other justices, I'm sure, are thinking about the same things. In other words, that they are also weighing these issues of individual rights versus what the Constitution requires or what the law requires, or what is beyond the law. So it's the thing about Kennedy was that he became the one whose personal decision made these changes or made these differences, and it's a bit worrisome when great and important decisions as these were are decided 5-4.
Mm-hmm.
So obviously, as you say, the other 8 people on the court, are also, I'm sure, very carefully weighing all these issues. But it depended on this one justice's, heartfelt and understanding of what was an important personal right. It's moved the country along, but should a democracy be, dependent on one judge's feelings about these things?
Well, I think you've said this, but I'd be interested to hear you say a bit more on this. As a historian and as a teacher of constitutional law, do you think that the Supreme Court does have a more active role? I don't know over what period, the last 20 years, the last 30 years, in defining some of these important social issues that have come before the court than it has in past times in our history. I mean, I'm thinking of time, during the Civil War, issues of slavery before, during, and after the war, the Civil War, and other times in the early part of the 1900s, very important cases in defining antitrust and in business and in labor rights, for instance. Do you see today the court having a more prominent role, and what do you think about that?
I think that obviously these other issues that the court decided in earlier periods were extraordinarily important, but in some ways these new ones are more personal. They really are the government in your bedroom, one way or the other, or the court, in a way that desegregation and labor rights aren't. I mean, those seem more sort of generally political issues that have constitutional resonance, and certainly slavery is extremely important. And I'm not to say that isn't personal, but these get to something that is very private, and you wonder whether. I mean, it would be better if the government left it alone altogether, everybody. And maybe that's the move that they're making. It's just that it seems to have gotten into things that are, that I can't imagine ever having come up 100 years ago or 50 years ago.
But it's also, doesn't it coincide, or don't some of these privacy decisions by a Supreme Court, the Griswold case and contraception was in the what was in the late 60s? Is that when Connecticut versus Griswold came out? Was before Roe versus Wade by a few years.
Yes. There were 2 of these sort of lead up cases on contraception that before Roe.
And then it coincides with a time in our social history where we have a greater focus, a greater struggle, if you want to see it that way. Certainly a lot more attention on individual rights, the civil rights movement, the women's rights, gay and lesbian rights. I mean, these are movements in our country's social fabric that have taken shape in ways that they didn't in prior generations.
That's true. That is, that certainly is true. I think that the only thing that, and that it's important that if people's rights are being intruded upon, that that be stopped. It's just to have one person make that decision for all of us, no matter how heartfelt isn't comfortable. And you think if it was that important and that clear, that wouldn't have been 5-4. It wouldn't, that but that's where we are, unfortunately. So there's some real, really serious legal and constitutional theories and sensitivities by all the other judges that are splitting the court and leaving it to a swing vote.
Well, that's why I'm going to come back to this idea. That's why I was really curious to explore a bit this idea of a swing vote, and if now Kennedy, for better or for worse, like it or not like it, and sometimes you might like it, and sometimes you might really not like it. But
that was true. Everybody had their own views of it.
I mean, let's not. Cases. We've talked about some decisions that there are segments of our country that would stand and cheer for. I mean, the same-sex marriage case of upholding Roe versus Wade. There are lots of people that would be very excited about that. But don't forget too, that Justice Kennedy authored the Citizens United opinion, which really changed very dramatically how our elections are financed, and there are lots of people that would be very unhappy about that decision. So and even in the area of gay and lesbian rights. In 2000, Justice Kennedy wrote the opinion in favor of the Boy Scouts, who didn't want to let Scout leaders who were gay or lesbian, I guess were gay, since talking about the Boy Scouts. But so he was not, this is not to say that Justice Kennedy was someone who could be easily pinned down. I know you've made that point, that sometimes you perhaps didn't even know where he stood, but I'm fascinated by what the insight you shared in regards to the Heller decision and the role that, at least we think, that Justice Kennedy may have played in how Justice Scalia wrote that opinion. Because we don't really get a window seat into the inner workings of how these opinions are crafted, but it is a process ultimately that it isn't often that it really truly comes down to just one person's feelings about a subject that defines an issue. There is a process that goes on in how these opinions get compromised over and worked through, and that addition to the Heller decision, I mean, that seems like a pretty good addition to make sure that there can be some room for reasonable government regulations, even of a right as spelled out in the Second Amendment.
It's just led to quite a lot of more cases and confusion, but that's true. And when you were talking about whole sections of the country cheering, there was a lot of cheering about that and gnashing of teeth on the other parts of the country.
Absolutely.
So that was, one of these really contentious cases. I suspect that there'll be some other judge that people will fret over in the future.
Let's say a few words about Judge Kavanaugh then, because one of the things that President Trump has made pretty clear, and he actually campaigned on this and asked people to almost regard this as a campaign promise, and now he's making good on it. That is choosing somebody if he'd be given the opportunity, and he had that opportunity with Justice Gorsuch, and now with Judge Kavanaugh to replace Justice Kennedy. He's going to appoint a judge who will overturn Roe versus Wade. I mean, I don't think
that. Well, I don't think that's going to happen. I mean, not that he's not going to appoint people, but I don't think that case is going to be overturned. The thing about that is it's sort of been existing law for some time, and modified by Planned Parenthood versus Casey, it still stands, is that there are various aspects of it, like, suggestions that after the 5th month, abortion not be legal or something like that. Those sorts of things I can imagine courts dealing with, but I can't imagine that any court or any additional justice is going to make any serious change in abortion as a right. What I think that Kavanaugh will do, though, is sort of see a more modest role for judges. I mean, he is like Scalia, a textualist. He sort of looks at what the law says, and rather than trying to read into it, things that aren't explicitly there. So, he has a sort of different approach to the law and much more, I don't call it ideological, but a much more straightforward approach of how he has seen cases, because he's had 12 years of a record of on the courts of actually adjudicating a whole series of cases. So I think he will be more clear to understand how he gets to the result that he does by looking at the text of the Constitution, the text of a statute, what it meant at the time that it was passed, and generally, a less expansive role for the court, leaving more things to the Congress. So I guess that's how I sort of see it. I don't see him, overturning, major decisions so much as sort of approaching these things, in a respectful manner, and looking at the way that the law is developed.
Professor Malcolm, in what areas do you think that will that approach, that is a more modest approach, as you described it, leaving decisions about what is appropriate or not, unless something is actually, clearly unconstitutional, but leaving decisions more to Congress, and of course also leaving decisions more to state legislatures as well when state law issues come before the court. Where do you think those issues will be most prominently seen as far as what types of cases and controversies are likely to come up in the next few years? Do you think more in these social
asking
issues?
A historian to be a prophet? I don't know.
That's true.
Basically, but I think he takes a different view on this Chevron deference to defer to administrative agencies when in doubt about statutes, and I think that he's much more likely to disapprove or at least look very carefully at anything that any opinion that they come up with that doesn't seem to be within the bounds of their authority. So I think that that's more likely to sort of rein in what agencies can do to sort of expand their authority.
Well, see, that's fascinating.
And I guess
that's fascinating that you brought that up, because I've read that, and I think we need to take a step back and explain a bit more about the Chevron case and what this means, because I think this is really important, and I think we're going to see the Supreme Court get involved in a lot more of these Chevron type disputes. I agree with you, but could you say a bit more, just by way of background, of what that involves?
Yeah, actually, it was sort of a footnote in a case, but the idea was that when an executive agency had a particular opinion that was sort of there was some controversy about its authority, that the Supreme Court would defer to the agency's view of it. And there have been a lot of issues in the last few years of agencies, sort of expanding their authority in ways that, seem and sometimes doubtful. And the court deference every time has been really sorely tested. And I think that some of the conservative members of the court, and I think Kavanaugh, will push back against that and keep the agencies more closely aligned with what their authority is supposed to be and what their statutory authority is. So that will be important because
go ahead.
Because I think that there's been, the Environmental Protection Agency and the IRS and, all kinds of agencies, government agencies have been busy, passing regulations, some of which are doubtful. And when they come before the courts always yield to what the agency thinks its power is. They just keep growing. And so the court has really taken this position in the past of always sort of siding with the agency's interpretation of its role. And, I think that the time has come where maybe that's gone too far, and the court is going to take a much more careful look and not defer, just look for itself at what the statute and the authority ought to be.
See, and that's so in the Chevron case, this I think was a 1984 case that came before the court on this, and set up this practice of the Supreme Court deferring to the agency, EPA, FEC, FDA, all the the alphabet soup of agencies that deal with so many aspects of all of our daily life and our business life in this country. Congress may set up that agency, but then the agency sets about passing all kinds of regulations on a whole variety of things that Congress never specifically addressed in its initial authority in creating that agency. But and I guess in a certain way, there's a parallel here to the Constitution. Framers passed the Constitution, and then the court is interpreting that Constitution based on a lot of things that aren't actually in the text of the Constitution. But the difference here is you're saying that a judge like Kavanaugh, and I think Justice Gorsuch should clearly be in this ideological viewpoint as well. Instead of deferring, you're saying here a justice is going to step up and say, my role as a justice is to say what's not okay and what is okay. I'm not deferring. I'm going to actually be a more activist judge, so to speak, on this particular issue.
I guess you could call it activist, but basically as textualists, their guidance is what is the statute that created that agency? What is the official authority Congress gave it? And I should say, to a certain extent, Congress has been remiss because they've set up agencies or passed legislation and leave agencies to fill in the details, just as you say the founders did with the Constitution. So they are busy filling in the details, and some of that, maybe Congress should have done it itself. But when it comes to, what seem to be new extensions of agency powers, the court is not just going to automatically defer. It's just going to take a close look at it. And I think that's probably a healthy thing. I don't think they should just always say, no, you can't do that, but that needs to be, carefully considered. Is it within the scope that was originally intended this agency have or not?
So you see,
that seems to be one thing. Yeah.
So though I admit it's very unfair to ask you anyone to look forward to, and especially
to prophesy,
constitutional historian should be looking backwards. But if we have to, it sounds like you're saying with Justice Kennedy's retirement and the likely confirmation, even if it comes after a prolonged battle, of as long as the president's party controls the Senate, the likely confirmation of Judge Kavanaugh to replace him, it's more likely we're going to see some changes on the court in terms of how agency power and authority gets decided, and less likely that we're going to see some of the things that people might associate with Justice Kennedy's legacy, like his same-sex marriage opinion, his upholding of Roe v. Wade and the Casey decision. Less likely we're going to see fundamental rights decisions overruled. But then, of course,
and more attention maybe to sort of balance of powers and federalist issues and things like that. Yes.
Okay.
That's what I think is likely to happen. I don't think that that these opinions of Kennedy are going to be overturned, but I think that the sort of general demeanor of the court is going to be more focused on interpreting the law and the Constitution in a much more strict way, and apparently Kavanaugh said the text of the law is the law. So that's his view of it. Let's look at what it's saying. And that's, at least at the end of the day, you'll have a better sense of where he's likely to go than with Kennedy, whose heart went this way and that way. And, maybe for his own feeling of what was the important individual rights that the court needed to be the one to decide. So this is maybe a more modest Supreme Court. And in some ways, maybe it's time for that to happen. Because I think very big and important decisions have been made, and maybe now it's time to sort of digest those and look at the way that the government's actually working.
Professor Joyce Malcolm, thank you so much. Professor Malcolm, the Patrick Henry Professor of Constitutional Law at the Antonin Scalia Law School at George Mason University, and the author of a new book on Benedict Arnold, which I have to check out. Professor Malcolm, thank you very, very much for being on Good Law, Bad Law. I really appreciate your time. Thank you.
Well, thank you very much for inviting me. I enjoyed it.